CLJ session on white collar crime in India. I'm Neeha Nagpal, joined by Mr. Malak M Bhatt, my colleague, who's an AOR of the Supreme Court, and we're in discussion on investigations into white collar crimes in India. Hi, Malak.
Hi.
So, Malak, typically I've seen that in the criminal law process in white collar crimes gets triggered either by a private complainant who's in a contracting party,
Right.
or by the banks when an account turns NPA and they conduct a forensic audit and refer it to an investigating authority. What's your view? I mean, would you think that there is another way that criminal investigation into white collar crimes can
So you're right. Typically, unlike other cases where the state really can take action on its own, white collar crimes are peculiar. The peculiarity of white collar crimes is that you require an aggrieved party in the form of a private complainant, or you require an aggrieved bank which has lost, who at least alleges that it has lost out on money to actually take the action forward, either under the various RBI circulations that are there out in the public domain, or to initiate fraud or willful default, or for that matter, even initiate a private complaint directly to one of the investigating agencies.
So when it's a private complaint, actually one has seen it goes to the economic offences wing.
That's right.
The banks typically then, under the fraud circular, they declared an entity of fraud, refers it to the CBI. Malak, when you talk about peculiarities in the white collar crime investigation scene, I've also noticed that, what typically happens is that there is a multifarious investigation that starts. That is unique only to economic crimes, and that does not happen with typically, crimes of theft or murder or any other typical crimes of blue collar crimes, as one can call them. And don't you think that sort of jeopardizes a lot of one's personal liberty, of course, and also is double the trouble and double the hassle? And don't you think today we should have some collation of all these laws so that multi-investigation is kind of limited?
No, absolutely, and which is why a lot of the clients, the problem that they face with white collar crime issues is the multiplicity of the very same proceeding. So let's take an example. In most bank fraud cases, the initial complaint that is being made to the main agents, which is either the CBI or the police, is largely on the grounds of forgery or cheating, which become predicate offences for the purpose of the PMLA. So you are looking at a CBI inquiry, you are looking at an ED investigation. At the same time, if the level of the fraud is very egregious or say is shocking the public conscience,
then investigating office also comes in. So the difference between a PMLA investigation and a CBI investigation and SFI investigation is this: that the CBI investigation forms the predicate offence, and without the predicate offence FIR, PMLA does not, ED does not come into the foray. And typically, any economic offence leads to, upon registration of FIR, leads to a ECIR being registered. Now, there is a whole debate on whether the PMLA authorities are supposed to make that ECIR public, which they don't do till the complaint by them is filed or not. That issue is pending in courts. The issue insofar as how does SFIO come into the foray? The SFIO comes into the foray when the Ministry of Corporate Affairs passes an order under Section 2121 of the Companies Act 2013. Yes. The triggers for all of them are, of course, the trigger could be either SFIO order comes first and then the FIR comes in. And of course, upon the FIR, you have the PMLA coming into foray. My concern has always been with how does one handle investigation into all these agencies simultaneously, because once they get triggered, it's like a domino effect.
Yeah, so couple of points which probably we can discuss right now is one, somewhere one will have to broach the idea of clubbing investigations to ensure that the party does not face to that extent a double jeopardy, because in essence if one goes to see the offence of cheating and the offence of fraud under the companies like the SFI looks at, they're largely or predominantly the same nature.
The ingredients are the same. Correct. Because 420 requires wrongful gain or wrongful loss upon a misrepresentation. Similarly, the definition of fraud under 447 of the Companies Act has similar ingredients.
Correct.
So there is a whole amount of double jeopardy that ends up happening there.
And apart from that, the other issue which one will have to discuss is to how to drive the investigation in such a multiplicity or a multifarious situation, so that you don't end
Consistency.
correct, you don't end up contradicting yourself. At the same time, you're driven towards cooperation, but at the same time guiding all the investigation in the same direction. But ultimately, not every transaction is the same, and not every agency looks at every transaction in the same manner.
So, Malak, while that's valuable input, but I also have noticed that, in typically a seasoned, more conservative criminal lawyer has always said that, but the lesser said during investigation, the better it is. My own personal view when it comes to white collar crimes or economic offences is that you should cooperate, you should explain the transaction, explain the business model, because what may happen on many times is that a transaction particularly may seem like a transaction of siphoning of funds. Whereas, typically I'll give you an example where company A is the borrower. Company A has borrowed the money from the bank to invest it in a power plant, hypothetically speaking. But it's for the purpose of taking of coal agreements, its SPV has got the coal procurement agreement. So necessarily that fund will also have to go there. Banks may perceive it on a later date as diversion of funds to a third entity and not directly into the power plant. But so one will have to sit and explain these transactions, so you have to give out a lot more than you traditionally give out in any other criminal investigation. While cooperating with investigation and ensuring that there is consistency across the board of all the agencies, what are things that one should be careful about?
So three things that immediately come to mind is you're right. One need not always hide everything as far as defense is concerned, because here it's not about opening up the defense but explaining a transaction, and that's more so important considering that bank action starts in most proceedings on the basis of a forensic audit or a forensic report. So the first mandate that you have to take care in such an investigation is to displace the assumptions and the findings of that report. That can only happen once you go on and explain two things. One, the manner in which you conducted the business, and how the banks actually treated your business to be a bona fide transaction at the relevant time. Number two, and the other important thing which one has to take care is because multi-agencies are involved, issues of attorney-client privilege, issues of disclosure of confidential information will somehow come in. So one will have to balance out the rights that you have as an accused, but at the same time the underlying objective of getting out of these investigations in a quick manner. So with these issues in mind, you will have to drive the investigation by not holding back everything, but at the same time you would have to ensure that you are giving all the right information, so that the investigation the agency does not feel that you are holding back on the information.
Exactly, and thank you so much Malak for that. And I think to recap, essentially in a multifarious investigation into an economic offence, one has to maintain consistency, cooperation, and get the business model right to be able to put it to the agencies.
That's right.
Thank you for joining us today, and I hope it's been an enriching experience. Thank you.
Thank you.